Okay, so, officer, those are my questions. If you'd stay there, Mr. Marley's going to have some questions for you.
Okay, thank you.
Mr. Marley?
Thank you, Your Honor. Officer, you have a discipline history with the Yorktown Police Service, isn't that right?
Your Honor, the Crown is objecting to
I'm
that.
sorry, I didn't actually hear the question.
My question was, you have a disciplinary history with the
Disciplinary.
Yorktown Police Department.
There's an objection to that, Your Honor. The Crown respectfully submits that any type of questioning as it relates to this officer's past history with the police force is not relevant to what happened on this particular night and the specifics of this particular night.
Mr. Marley?
Your Honor, it's my understanding that this officer was formally reprimanded by a superior officer for what I would characterize as an offense of dishonesty. In my respectful submission, to the extent that it is a formal reprimand, akin to a criminal conviction, it is proper grounds for cross-examination under the Canada Evidence Act, specifically prior poor conduct on the part of the witness.
Prior disreputable conduct on behalf of a witness.
Yes, Your
Honor. Mr. Houle?
Well, again, Your Honor, the Crown's position is that, I mean, we haven't got the specifics yet from Mr. Marley about what that is, and I suppose the objection is before the court. The court may wish to hear a little bit more.
He said a reprimanded by the police department. I don't believe he used the word offense of dishonesty, but an instance of dishonesty, presumably, although Mr. Marley didn't say it, arising out of his duty as a police officer. I would think, because otherwise, well, he could conceivably. Ordinarily, Mr. Houle, Mr. Marley, you may ask the witness to be excused during this discussion. Witness, you're asked to be excused, but you don't have to go. You can stay.
Well,
all right, is your objection, Mr. Houle, that your initial objection was that it was irrelevant? Then you said, well, wait a minute, he didn't provide any detail of, I'll say, the offense with which this officer appears to have been charged internally. I'll use that word loosely.
Well, since the officer's not present.
Yeah, he's not here. He's not here, but
it's the Crown's information that the officer at some point could not account for missing police buy money that was issued to him.
all right. As an undercover.
As an undercover officer. That he received a reprimand for that, but there are certainly no details and no indications that there was any form of dishonesty on the part of this officer as it related to the reprimand. The reprimand could have been as a result of negligence in misplacing the money.
Poor accounting.
Poor accounting. There's certainly no specifics indicated that the reprimand suggested in any way that the officer had stolen the money or was somehow involved in a dishonest proceeding. So in my respectful submission, given that lack of detail, it would call upon the court, I suppose, to speculate as to whether there was dishonesty or negligence. If it's negligence, it's not relevant, in my respectful submission, to the officer's evidence as it relates to this specific set of charges.
That's a fair enough statement, but cannot, if Mr. Marley puts it to the officer, saying you were reprimanded, there was money missing under these circumstances, is it not then open to the officer to say, well, yes, that's true, but it had nothing to do with dishonesty? I doubt if he would say that. He would say, well, you know, I made poor accounting. And then I'm wondering whether that might be a collateral issue with which Mr. Marley, with the answer with which Mr. Marley is stuck, because it's a collateral issue, assuming that's what the officer says. But if there's, all right, I'll leave it there, and then I'll ask for Mr. Marley to respond on that basis.
Right, thank you,
Mr.
sir.
Marley?
Your Honor, in my respectful submission, whether it's a matter of negligence or a matter of dishonesty, and I have a suspicion as to how the officer will answer. In my submission, that goes only to the weight that you may place on the evidence, but the fact that he has been formally reprimanded in the past by his own police service, in my respectful submission, is admissible evidence. If my friend is objecting as to its admissibility, in my submission, it is admissible. Ultimately, what use you choose to put the evidence to, in my submission, is a matter of weight.
Hold on. Mr. Houle, this officer is not an accused, so it's not an issue. For instance, if he were an accused, he could only be cross-examined on convictions. He's an ordinary witness. Can he not be cross-examined on possible other discreditable conduct that doesn't amount to a conviction of any kind, because he's a witness, not an accused? But as Mr. Marley says, depending on his answer, I may or may not give any weight to the suggestion that Mr. Marley is going to make, especially if it's a suggestion that the witness does not adopt. Is it, Mr. Marley sees it as a threshold issue that he ought to be allowed to ask the question. What you say he ought not to be allowed to ask the question.
The underlying test, sir, is still relevant.
Yeah.
But it's a Crown submission that given the essentially fishing expedition that Mr. Marley is on with regard to this witness, that it hasn't passed that threshold test of relevance.
Well, if now the officer's out of the room, but if the officer says, yeah, I used the buy money, I used $10 of the buy money to buy my partner and me lunch, something he shouldn't do, it shows some element of dishonesty, may not be as much as Mr. Marley wants it, but can it not, I think because he has some basis for asking the question, because presumably he has some type of record of the officer that shows the reprimand, whether it's what Mr. Marley suggests it's for or what the officer may say it for. It seems to me that it might be relevant to his credibility. So I'm going to allow the question, but having said that, it may be a collateral issue and Mr. Marley may be stuck with the answer that he gets. I don't know. Well, that might be something that we'll argue at the end of the case.
All right, thanks, sir.
Officer, in the past, you've been the subject matter of disciplinary proceedings within the your town police service, correct?
Correct.
On one occasion, you were formally reprimanded by a superior officer for having buy money gone missing, right?
That is correct.
You were working as an undercover officer. You were given buy money, right?
Yes.
Money which your police service and the taxpayers of your town provided to you to do your job, right?
Right.
And it's gone missing.
Correct.
Right. You misappropriated it.
Correct.
And in the course of that, obviously, you were formally reprimanded by your police service, correct?
Correct.
You've also been charged with a criminal offense, isn't that right?
That's correct.
Well, again, sorry, just hold on, witness. Again, the Crown will make a similar objection to what it has already made as it relates to the reprimand. Again, this would be an issue that the witness would not be present for submission.
Yeah, the witness isn't here.
As I understand the situation with regard to the criminal charge, that in fact this officer was charged, but ultimately the charges were withdrawn by the Crown. And in my respectful submission, any reference to that or any cross-examination to that is not relevant. to a charge that has since been withdrawn. It is highly prejudicial, and there's no probative value to it.
Mr. Marley hadn't said that. Are you telling me that he was charged, but the charge was withdrawn?
That's correct, sir.
Mr. Marley, on that basis, what relevance does it have if the charge is withdrawn? Either if he's found not guilty or the charge is withdrawn, it's as if it never happened. He should have the same benefit of our presumption of innocence that any accused person has.
As Your Honor's already observed, this man is not an accused person. This is, in my respectful submission, another incident of prior disreputable conduct upon which Your Honor can perhaps rely on for the purposes of assessing overall his credibility.
Well, the problem I have with this, and I'm reading from Martin's, and it says, this is the summary at Canada Evidence Act, Section 12. This section does not limit the otherwise permissible defense cross-examination of a prosecution witness on the particulars of discreditable conduct that resulted in conviction. In fact, it does not limit otherwise permissible cross-examination of any witness other than the accused, which I think both you and Mr. Houle agree. A witness may be cross-examined about any discreditable conduct, including the circumstances of a charge for which the witness received a discharge or an outstanding charge. Where I part company with you and go towards what Mr. Houle says, the charge was withdrawn. If you wish to get into why it was withdrawn, maybe a witness didn't show up, maybe something happened, we end up with a second trial within this trial, which detracts from the focus of this trial. I'm not prepared to allow that question. If he had been convicted, or if he had been convicted and a discharge was registered, I think you're on solid ground. But once the charge is withdrawn, that means that a quasi-judicial officer like the Crown has made a decision. I'm not here to go behind that decision, and I think it would detract from the focus of this trial to allow you to enter into that inquiry.
Thank you, Your Honor.
All right.
I'll turn the witness's attention then, if I may, to the events of June 12, 2009.
All right.
Officer Fantasia, you were dressed that day like any other person who might be in the park that day, right?
Right.
In other words, you were dressed in order to fit in.
That's correct.
You were dressed to look like a drug dealer or a drug user.
I was dressed to fit in.
Right. Well, isn't it you've already offered the evidence that this park is somehow notorious, according to you, for illegal drug activity, right?
I do.
Right? And so presumably you dressed in order to go there that night in order to look like you were one of the people who might be involved in illegal drug activity, right?
I dressed like someone who might be there that day.
To purchase drugs, because that's what you were going there to do, right?
I was going there to purchase drugs.
Sure. So you dressed looking like somebody who was going there to purchase drugs, right?
I am not certain what you're implying there. Are you?
That was your cover. That was the appearance you wanted to give. Isn't that right?
I wanted to dress like somebody who would be there that day.
To purchase drugs. In other words, if you went dressed...
Let me ask for a clarification then. What's the difference between somebody...
Hold on, officer. Your job is to answer questions. Your job is not to ask questions. It's the job of the Crown Attorney and the Defense Counsel to ask questions. It's the witness's job to answer them.
Thank you, Your Honor. You didn't go to the park that night dressed like that, did you?
No, I did not.
No, because people who buy drugs don't normally have a jacket and a tie on, right?
In that neighborhood, no.
No. So you went there looking like somebody who was going into the park to buy drugs. Doesn't that just make sense?
Yes.
Thank you. And you saw Mr. Friedbrain, right?
Correct.
Now, you've been down the road with Mr. Friedbrain before, right?
Yes,
Down the road, I mean, you've dealt with him before.
I have.
You know what he's been found guilty of in the past, right?
I do.
Right. And you don't like him.
I don't like him, no.
No, because you know he's accused you of framing him in the past, just like he accused you that night, right?
He didn't accuse me of framing me on that night. He said he did not want me to frame him again.
Right. Implicit in that comment is the suggestion that you framed him before.
Yes.
Right. And you knew that that's how he felt about you.
I knew that's how he testified in the past.
Right. And so he's there in the park, and he's perfectly entitled to be there in the park, isn't he?
I may have ascertained later on whether or not he was entitled to be there. I don't know his parole conditions.
No.
So it is possible that he was not entitled to be there.
Right, but you never got to the investigation part before it got physical between you and him.
That's correct, because I
Right.
was actually asking him to leave so that there would be no investigation and to give him the benefit of the doubt.
Which you had no right to do, that is, ask him to leave.
I have a right to ask him to leave.
You have a right to ask him, but you have no right to expect that he'll leave.
I suppose not.
He's free to be there,
As far as I was aware at that point, correct.
sure. And he even offered to you an explanation as to why he was there, right?
Yes, he did.
Yeah, he's coming back from an NA meeting, right? Now, you might have thought, given your predisposition towards Mr. Friedbrain, that was a little suspicious. At 11:30 at night, he's coming home from an NA meeting, but you didn't even bother to ask him for any proof, did you?
No, I did not.
No, you just assumed he was lying.
I wouldn't say I assumed he was lying, but I would say that it seems a little bit odd that he would be going to an NA meeting.
Would have been very easy to ask him for some proof and confirm the truth or the falsity of what he was saying, right?
Well, that's not what I was there that day under assignment to do.
No. So you're in the park there trying to buy drugs from people in order to prosecute them. You're there in the park and you see Mr. Friedbrain walking through the park, right?
Correct.
You had the option to just let him go, to lie low until he walks through the park and so he doesn't blow your cover. You could have just let him walk on by, right?
I could have, however, I was in the park and he was in the park, and if either of us were to happen across each other during my assignment, he would have blown my cover.
Right. But you had the option to lay low and just wait for him to walk on by. You've already acknowledged that, correct?
Yes,
But instead, you approached him.
that's correct.
Right. And you told him to get out of the park.
That's correct.
And he said, to heck with you, I'm not doing that. I'm entitled to be here. Or words to that effect.
I don't believe he said I'm entitled to be here.
Right. But you knew he was entitled to be there. You've already acknowledged that.
I've acknowledged that I didn't know whether or not he was entitled to be there at that time.
You had no right to direct him out of the park, did you?
I had no right to cause him to go out of the park, no.
Thank you. And when he refused to do what you wanted, you got physical with him, isn't that right?
No,
Just
that's-
before the witness answers that question, the trial here is not as it relates to Mr. Friedbrain. The trial is focused on, or ought to be focused on, the charges as it relates to this accused.
Well, hold on.
My respectful submission, Mr. Marley has now gone beyond the scope of dealing with the background information leading up to the physical altercation between this this officer and Mr. O'Brien.
That might be a valid point with respect to count one, which is the assault, but count two is an assault while he's in the execution of his duty.
Yes, sir.
And if he's exceeding his duty as a police officer by telling Freddie to leave the park when he knows he had no right to do so, depending on what comes out of that, there may be an assault, but he may have exceeded his duty, in which case, even if there's an assault, it may not be an assault of a police officer in the execution of his duty.
All right, sir. Thank you.
Thank you, Your Honor. So acknowledging that you had no right to direct him out of the park, things then got physical between you and Friedbrain, right?
correct.
And what happened, I'm going to suggest, is that you took him to the ground began smacking him across the face. Isn't that right?
No, that's not anywhere close to right.
You were already predisposed against this man. He's now in the way of your undercover operation. He won't leave the park. You take your frustration out on him by taking him down to the ground and slapping him across the face repeatedly. Isn't that right?
That is not right.
And it's
I
at
was
that
not, I
point-
was
Well,
not predisposed
Hold on,
toward
Mr.
him.
Marley. You have to let the witness answer the
Thank you, Your Honor.
question.
Apologize, Your Honor.
My previous dealings with him is not a predisposition toward him in any way. Just because I know that he happens to be a federally paroled inmate and that he is convicted of past offenses does not make me predisposed toward him negatively.
Whether you were or were not predisposed, you certainly attacked him physically. Isn't that right? Took him to the ground and smacked him across the face repeatedly.
I was pushed, and in return, him pushing a police officer whom he knows to be a police officer, I then proceeded to take him to the ground by applying a hip toss, which is a technique that police use all the time and are trained to use all the time.
So you take him to the ground and then you repeatedly smack him across the face.
Mr.
right?
Marley has made this suggestion, and I'm not sure how many times. He's got the same answer from the officer. I'm not sure
Well,
how
he
many
hasn't.
times.
The officer agreed he took him to the ground.
But Mr. Marley continues to make the suggestion to the witness that the witness slapped him across the face numerous times.
Well,
We made that suggestion several times, and the witness has answered that question several times by saying he did not do that. That's my recollection.
No, he says he denied he took Freddie down and was slapping him. He's now admitted that he was pushed and then took him down. So in effect, Mr. Marley asked two questions in one. So he now says he was acting within his duty. I was pushed and I responded. Now, I think Mr. Marley asked two questions at the same time when he shouldn't have. Excuse me. Excuse me. I'm going to allow the second question, which was the slapping of the face several times, because he denied, the original question which he denied was a suggestion that he took Freddie down and was slapping him. He denied that. Now, I don't know if that was in relation, at that time, I don't know if that was in relation to the taking him down or to the slapping him. He now agrees, he said, I was pushed and therefore I took him down, and there's nothing wrong with that. The next question about the slapping, I think, as a single question, I will allow.
Just, it should be noted for your honor's notes that throughout the officer's evidence, he's indicated in chief and in cross with Mr. Marley that he took the person down.
Oh, absolutely, I agree with that.
Thank you.
I agree with that.
Officer, you justify in your own mind your application of force towards Mr. Friedbrain on the basis that he had assaulted a police officer by pushing you, correct?
Correct.
Right. The gentleman who's in the park, my client, who's observing this, you now know he must have been there and observing it, correct?
That's a fair assumption.
Sure, thank you. That man doesn't know you're a police officer.
I can't speak to what he knows and doesn't know.
Well, you've never met him before, right?
Correct.
You have no reason to believe he knew you were a police officer, right?
Correct.
You knew that Mr. Friedbrain already knew you were a police officer, so you didn't tell Friedbrain you were a police officer.
That's right.
You weren't dressed like a police officer,
That's right.
and you were wearing no markings, badges, vests, nothing that would indicate you were a police officer, right?
Right.
Right. So at the point that you apply force to Mr. Friedbrain and take him to the ground, whether you slapped him across the face or not afterwards or not really doesn't matter. The point you take him down, my client has no way of knowing that you're a police officer engaged in the execution of your duty, right?
I haven't had the opportunity to respond to whether or not I slapped him in the face. I did not slap him in the face.
Well, according to Mr. Hull, you've already denied it a number of times. I wasn't going to repeat the question. But you're saying you didn't. I'm suggesting you did repeatedly.
Okay.
Agree or deny?
All right, well, at this point, Mr. Hull is correct. He's now denied it. Quite frankly, I was going to say, are you going to ask him if he slapped him in the face? He's now denied it.
All right.
But your next question is the one that I wanted him to answer.
Thank you very much. At the point that you take Mr. Friedbrain to the ground, You've not said you're a police officer.
Correct.
You're not dressed like a police officer.
Correct.
Right? And you don't know this man, Mr. O'Brien, so he has no way of knowing you are a police officer, at least as far as you know. Right?
I suppose I could say that I took him down like a police officer would, and I was on top of him like a police officer would be in order to effect an arrest. So using his abilities to deduce what I was doing, perhaps he could have paid better attention.
For all anyone knows, Mr. O'Brien or anybody else in the park that night, this is one drug dealer or drug user beating
Arresting
up on another
another.
one. Right?
Arresting another one.
You took him to the ground, correct?
Yes, I did.
And at that point, all anyone would know is that there was a physical altercation between two people who at least were dressed like drug users, right?
I agree with that.
Thank you. And so immediately after you take Mr. Friedbraid to the ground, you sense that there's somebody else there, correct?
Yes.
And immediately after you sense that somebody's there, you say something, correct?
Yes.
And that, you don't know whether that was heard by Mr. O'Brien or not. You've already conceded that point in your evidence in chief, right?
I conceded that based on his actions right after I said it, it would be very odd for him to have come after me.
Thank you. And so the fact that he did in fact come after you is pretty good evidence that he didn't hear that you had said you were a police officer. Wouldn't you agree?
I'd say that is a logical conclusion.
Thank you. And then what happens is that the two of you, that is you and Mr. O'Brien, become engaged in a brief physical altercation on the ground, correct?
He tackled me to the ground. We both attempted to get up. As I got up and began to say once again that I was a police officer, he punched me in the face. So I don't know if that's exactly what you're saying there.
We'll get to the punch in a moment. But before, as you are getting up, you and Mr. O'Brien are getting up. When Mr. Houle was asking you about this, you said absolutely not, you weren't going to show your badge at that point. Do you remember saying those words?
To whom?
To Mr. Houle, the Crown Attorney.
No, I'm sorry. Show my badge to whom?
Mr. Houle asked you whether or not you were going to show your badge to Mr. O'Brien, the gentleman who had just interceded in your altercation between you and Mr. Fantasia.
After I got up.
Friedbrain, sorry.
Oh, Mr. Friedbrain is who you're talking about.
No. Mr. Houle, when he was asking you questions, said to you, after Mr. O'Brien got involved, why didn't you show your badge? And you said, absolutely not. I'm not going to show my badge at that point, as if somehow it was going to blow your cover, right?
I'm not sure.
I don't believe that's what I said at all.
That's
Hold
what
on,
he said.
stop, wait.
Hold on, officer. I don't think that's what he said. It seems to me he said his badge, he was looking for his badge, he couldn't get it out. He said he wasn't going to blow his cover before all this happened. During the altercation between him and Mr. O'Brien, he assumed that his backup was coming and he wasn't about. But I don't think he said at that point that he wasn't going to blow his cover, because by that time, whatever else had happened, he had yelled, whether Mr. O'Brien heard it or not, before or after the punch, which is what one of the elements the Crown's going to have to prove. But clearly, after they got up off the ground, he had already yelled that he was a police officer. And then this other police officer, according to his evidence, and he didn't know where he was, how far he was behind, was coming up to assist him. But I don't think he ever said that he wouldn't pull his badge out because it would blow his cover at that point.
All right. Thank you.
Mr. Houle, is that your recollection
Yes,
of the
sir.
evidence? Yeah, thank you.
Then I misunderstood the import
Yeah.
of his evidence,
Yeah.
and I'll go on to something
All right,
else.
thank you.
Mr. Houle asked you, how long after you said, stay back off, I'm a cop, how long after that Mr. O'Brien came into physical contact with you? Do you remember?
It was a couple of seconds.
Thank you. You recall giving a statement in relation to these proceedings, is that right?
Yes.
Yes, thank you. Your Honor, may I approach the witness,
Yes.
please? I'll show you what I believe is a copy of your statement, starting on this page and carrying on to the second one. That's your statement, correct?
That's my statement.
And you gave that statement to the police for the purposes of explaining your conduct in the course of this matter, correct?
That's right.
And when you wrote it down, the events were fresh in your memory, correct?
That's correct.
And when you wrote it down, you were trying to tell the truth about what happened that night. Is
That's
that right?
Yes.
Right after the part of your statement which quotes your words, "Stay back, back off, I'm a cop," the very next words are, "within a second of saying this." Do you see that?
Yes.
So that's the truth, isn't it? It's not a couple of seconds, it's a second.
A second is an expression.
Within a second of saying this, I was tackled by the now accused. That's what your statement says, correct?
That's what my statement says.
And that's the truth.
That's the truth. Yeah.
Thank you.
I would say that it's not any different from what I said today. It
No.
was within a second.
It's for his honor to determine, I suppose, whether there's a difference between within a second or within a couple of seconds. The gist of it is this, the essence of the question is this. Immediately after you spoke those words, and you're not sure whether or not he heard them, Mr. O'Brien tackled you.
Within
A second.
a second.
Thank you. Then when the two of you are on the ground, up off the ground, you again attempt to identify yourself, correct?
Yes. As
But
I'm getting up, I'm attempting to say once again, I didn't get the entire sentence out, and I attempted to get at my badge,
Right.
which is not somewhere conspicuous because I'm an undercover officer.
Sure. We'll get to the badge in a moment. But the words that you said were, "I am a."
Yeah.
Right. And Mr. O'Brien never heard the end of the sentence
That's right.
because you never spoke it.
Because he punched me in the face.
Right. Because you never spoke the words, right? You said, "I am a," and you didn't get out the rest of your sentence, right?
That's right.
Right. And as you were saying, "I am a," you reached into your pocket.
Yes.
And at the point that Mr. O'Brien is dealing with you, he has no way of knowing what you're reaching in your pocket for. Right?
He has his powers of deduction, but no, I suppose not.
But
Other than me saying that I'm a police officer and then attempting to say it again and attempting to effect an arrest in the way that a police officer normally would. Other than those things, which are clear signs to an observer, no, he had no way of knowing that I was pulling out my badge.
it's easier for you now to, with the benefit of hindsight, sit there and deduce all of these things that he may have deduced. But this is all happening within the span of 30 seconds or less. Wouldn't you agree?
I'd agree.
Sure. And may or may not have been sufficient time for anybody to deduce anything, correct?
Correct.
At the point that you were punched in the face by my client, you had reached into your pocket and had said the words, "I am a."
Yes.
Thank you. You were struck only once.
Correct.
You went to your doctor
I did.
complaining of an injury to your face, correct? To your jaw, correct?
That's right. Yes.
Dr. Leland, your family doctor, made observation of your injuries as you pointed them out to him, and he said this to you: take Tylenol for the pain, and if there is continuing pain, come back and see me in a week.
That's right.
And you never did.
No, I didn't.
Those are my questions, Your Honor.